Neighbors to the video tonight. And tonight's video, I'm going to review a couple of the eviction cases that were stopped. We will update a couple of cases that did not get stopped. I'm going to get right into it. Now, I mentioned to you guys last week and the week before last about a pair of homeowners that were going to call in and let you guys know how they stopped the eviction judgment hearing. Now, in the first hearing, the judge, they stopped the first hearing, and in the second hearing, the judge recused himself. Well, the judge didn't actually recuse himself. The homeowners recused the judge. And a new state judge stepped in and scheduled another hearing and told the homeowners they needed to show up with an attorney. You know how the court tries to intimidate you. A couple of days later, one of the homeowners texted me a message that the other homeowner decided to give up. I was shocked because over 2 weeks had passed since the first hearing, and they were supposed to have a second hearing by a new state court judge. Well, we were going to recuse that judge as well because the judge has conflict of interest. The state is the one that's foreclosing, and the state pays the judge, licensed the attorney, and all of the sub-corporations that are attacking you and beating you down to take your property. This happened once before, and it sounds like the homeowners took the deal. They took the deal. It was either one or two things. They either took the deal for the cash for keys because even though they stopped the eviction, they didn't feel like they were going to win, or they took the deal for cash for keys. In most cases, these people want to find out who's helping them punch the attorneys in the face. So I'm not worried about it because if they took the deal and let them know where they got their paperwork from, it's just fine, because if they want to come down here and give me a hard time, they're going to have to get in the line back there. The line is, at this point, 22 attorneys maybe, or 23 attorneys long. That's how many letters I've gotten from attorneys from all over the United States that are letting me know that they think I'm practicing law without a license. Well, they don't have a damn license either, so I'm not sure why they're getting. And that's pretty much what I tell them. They don't like what I have to say. Now, we had two people get evicted. One of these people actually was in my online course, but they needed more help than I could provide them, and so they went with another paralegal who told them that all my stuff was ridiculous and it was just going to get thrown out of court. So they didn't use my stuff, and now they're facing the 10-day eviction process. She came back to me and, was trying to pick up and figure out where she needed to be to get back in control. But she didn't do the paperwork right. She didn't add the state in there. And since she didn't add the state continued the foreclosure process, the eviction process, and moved them up to the front of the line. So the sheriff showed up and gave them their thing. She's still trying to get the process right. She didn't add the state court to the action because she didn't understand that they needed to be, why I had them on there. And if you're in my program, you need to just trust the process and not worry about why, because you're not going to understand everything that I know. So if you did, you wouldn't need my help, and you'd be in a different situation. So she got herself jammed up because she didn't add the state like I told her to do, and she didn't file her lawsuit in federal court. So if you're in the eviction process, you don't have time to do the counterclaim and all that. Now, people have done the counterclaim and it's worked for them, but if you're about to get the 10-day protocol, or 7 days if you live in Georgia, I would file instead of doing a counterclaim, I would file that lawsuit in state court and then file it the same lawsuit in federal court. So that's how it's sad that we have to file this in two courts to stop the process, but we're getting it stopped. Most other people are getting it stopped if they follow the process. Now, one person's situation got bad because they didn't check the Pacer site. They failed to respond to 3 pleadings and 1 judge's order. So they get really, really grumpy when you don't respond, especially if you recuse one of the magistrate judges in the federal level and you're in their face about the shared liability of them assisting their attorneys. And so when you start using my stuff, you can't go sit down. You can't miss it. You can't miss because any little excuse they have, they're going to use. And when you fail to respond to 3 pleadings and a judge's order, you're pretty much toast. The judge is grumpy, and they're going to make sure that you don't file any more lawsuits or any more paperwork or anything else. If you're using my stuff, they want to get you shut down. And in this case, it was easy for them to get this thing done because the person didn't follow up on the Pacer site. They relied on the mail, and they relied on the mail. And when you rely on the mail, you're already losing 7 or 9 days of your response time just because of the mail. So, and I know everybody says, oh, well, you get mail time, whatever. Well, you know what? You don't need that shit if you're on the Pacer site keeping track of everything. Now, I received a communication from Carl, and this is good. We're done with the bad. This is good. I received a communication from Carl, who filed the 42 USC as a counterclaim in the state foreclosure case. Carl said the judge was really grumpy because he added the judge and the state to the foreclosure case. And the judge continued the hearing and yelled at Carl to get an attorney. The judge told Carl when he shows up with his new attorney tomorrow, he better be ready to explain why the judge should not hold him in contempt of court for adding the judge and the state to the illegal action. Should hold, I would have told the judge that I'm going to hold him in contempt of court because he took jurisdiction without an injured party, without legal authority, and he has conflict of interest because he's being paid by the state, and the state is the one that's doing the foreclosure. The state is the real party that's trying to steal your property. Conflict of interest, there's no injured parties, no counting of the money trail, and the judge is getting paid by the same people who are stealing your property. So, and I could go on, but I'll I'll end it there. Players intimidated Carl with the threat of being held in contempt of court. And they tell you need to hire an attorney. Generally, you're doing a good job. Now, they'll tell you that if you're doing a really bad job too. But when they yell at you and they have attitude, then you know you're doing a good job. When they tell you that, but they don't look worried or like they really care, then you're not doing that good a job. That's how that goes. Now, the new updates for the eviction process should be used to control the court process, any court process that you're in. And you guys should go to my YouTube channel and check out the live stream I did 4 weeks ago, or maybe 5 weeks ago. It says instructions across the front of the thumbnail. That video has the new strategies that we're using, when to move, what to move, whatever. So you should go and check it out. And the last several videos that I put together on blocking the eviction process, it's not just about the eviction process. It's about blocking the court process. So that information in there is not just for evictions. So don't paint yourself in a corner. Carl called me to tell me that the judge had threatened him. He needed to breathe in the paper bag. Their intimidation only works if they can fill you up with fear. And they can smell your fear 2 or 3 miles up the street while you're driving, while you're on your way to the courthouse. I'm serious. They can smell your fear. So Carl was intimidated that they were going to jam him up with a contempt of court. So I just like to keep things simple. So I asked Carl, would he be willing to be held in contempt of court to make sure his family's not homeless? And of course, he said absolutely. So then I asked him why he was freaking out if he was willing to do whatever it takes. If you're willing to do whatever it takes, why are you going to freak out if the judge is going to try to slap you? Okay. Now, with that being said, I'm not sure if Carl added the judge. I'm assuming he added the judge. And if you add the judge to your lawsuit, then the judge can't be up there saying they're going to do anything to you because the judge is a party to the case now and has to go hire an attorney. But sometimes, well, all of the time, they're not used to getting punched in the face. So they have a little trouble at the procedures they're supposed to follow when they're getting punched in the face. When you understand why, when you understand the why, you can talk crap to the judge or anybody else that's in your face. When you understand why you added the judge, when you understand why you added the attorney, when you understand why you added the parties, then it's a wrap. To stop the eviction process, we filed a 42 U.S.C. 1983 civil rights lawsuit in state court after we add the eviction court judge and the third party buyer and the third party buyer's attorney. We add all of those. And the reason that we file it in state court is because if federal court's too far away. When we file it in federal court stalls and gives them chance to get your ass into the eviction protocol. So we're having to file it in state court. Now, if you're not facing the eviction process, then you can file it as a counterclaim where you don't have to pay. If you're facing the eviction process, then you're going to need to file it in the state court as a new claim against the eviction process. So that's how that works. And the people that are doing following the process and the steps in the process are having real good luck. If you're facing this problem, you need to get over to my website at winningcourtnow.com and get your 42 USC 1983 civil rights lawsuit package and get started before you get jammed up. I'm also going to put a link to that package in the comment section. And I'm going to leave a link to my online course if there's anybody, any entrepreneurs or paralegal entrepreneurs or property owners, property investors who would like to make sure that they can protect their property. The online course is the bomb. Thank you guys for the privilege of sharing your time. I'll see you in the next video. Oh, don't forget to